All right, next is Miss Leona on page 4.
No fraud, Your Honor.
All right, thank you, ma'am. Good morning, ma'am. I do find probable cause for your out-of-county hold from St. Lucie County. It's a probation violation regarding a DUI, impairment, blood or breath alcohol. You're being held no bond. You're going to be transported to St. Lucie County to answer to these charges. Anything else on Miss Leona's case?
No, Judge.
Good luck to you, ma'am. Next on page 6, Miss Bacon.
No fraud.
No, okay, Miss Bacon. All right, Miss Bacon, good morning, ma'am. I do find probable cause for possession of cocaine and drug paraphernalia. Mr. Linder, first to you.
Judge, I'm asking that the court keep the bond in place. Ms. Bacon just appeared before the court on July 8th, last week, for delivery of cocaine. Your Honor kept the bond in place at $2,500. She posted bond and was released on July 11th.
Okay, thank you, Mr. Barbera. Okay, thank you. So I will leave the bond in place, Ms. Bacon, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Ms. Bacon, once COVID is over, you will need to reapply to make sure that the Public Defender's Office keeps representing you. Good luck to you, Ms. Bacon. I'm leaving the $1,000 bond in place. All right, next is Ms. Hogan on page 6, who has refused. We are proceeding in absentia on her voluntary refusal. Ms. Buckaloo is here on behalf of the state, and Mr. Romero is here on behalf of the defense. I do find probable cause. There is a signed warrant charging her with murder in the first degree, premeditation, 2 counts. I am finding a proof evident presumption great based on the allegations. I am going to hold her no bond. She will have to go before her division judge in order to have her division judge hear an Arthur hearing and make any determinations as to bond. I'm ordering no possession of firearms, weapons, or ammunition while her case is pending. And I'm also ordering that she not have any contact with any minors under the age of 18 while her case is pending. Is there anything else on Ms. Hogan's case that we need to address?
Yes, Your Honor. I'd just like to ask for the court to
order sealing the warrant and affidavit for the 90-day period due to the fact that although probable cause has been found, it is still a pending investigation with more work that needs to be done, and any information in that affidavit being released right now could taint any potential ID or witnesses.
Okay, thank you, Mr. Romero. Do you have a legal objection?
Yes, sir.
My colleague will address it.
Judge, I have no objection to that.
Okay, thank you. So I will sign an order sealing it, and I will provisionally appoint the Office of the Public Defender to represent Ms. Hogan during the pandemic. Anything else, Kate?
Thank you.
Judge, also, we would invoke the defendant's rights to remain silent and not to be questioned by law enforcement unless she's with her attorney.
All right, thank you.
The record is noted. Thank you.
Honor? So I didn't catch the name of the attorney that appeared representing Mr. Davenport.
It's a Milena Mompoint.
Thank you, Judge.
I supervised her a long time ago.
That long, man.
Like over 11, 12 years ago. All right, so I'm going to give a copy to Ms. Cooper in confinement, and then thank you, and then sorry. And then 2 copies for the clerk's office. All right, thank you. So that brings us to Ms. Cook on page 7, who is a second-time refusal. We're proceeding without her. I do find probable cause for possession of cocaine and drug paraphernalia based on her refusal. I am going to leave the bond in place, and I will provisionally appoint the Office of the Public Defender to represent her during the pandemic. Once COVID is over, she'll need to reapply. Anything else on Ms. Cook? Okay, thank you. Next is Mr. Crosby on page 8, and the listed victim is outside, so just give them a minute to get the listed victim. Well, I guess one of the listed victims, because there's multiple. All right, while they're doing that, I will make a finding of probable cause for 2 counts of battery, cause bodily harm, domestic violence, and dating violence. So just give me 1 minute. right, good morning, ma'am. What is your name for the record? All right, ma'am, and you are one of the listed victims, and you are here without an attorney. So I just needed to ask you, are you here to see what's going to happen, or did you want to tell me something?
I wanted to tell you something.
Okay, so please raise your right hand for me. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth? Okay, thank you. You can put your hand down, and now that you're sworn, please state your name again. All right, ma'am, you are one of the listed victims again, but you're here without an attorney, so I need to advise you that you previously spoke with law enforcement, so anything you say today can be used against you at a later date. Do you understand?
Yes.
Okay, thank you, ma'am. What is it that you wanted to tell me?
I wasn't a victim that night. We didn't have any physical altercation. What was told to the police that night, that's what I told the police that night, and what was told to them that got me on the record was said by someone who was there that night. It was late at night, so I think that got a misrepresentation of that. So there was no actual physical altercation.
All right, thanks, Mohammed. Does either party have any questions for her based on her testimony this morning?
No, Judge.
I do, Judge. Ma'am,
Go ahead.
are you in fear of Mr. Crosby?
No,
Was that a no?
She said no.
that was a no.
Do you want contact with Mr. Crosby?
I'm sorry, I can't hear you.
Do you want contact with Mr. Crosby?
One more time.
Do you want contact with Mr. Crosby?
Yes.
Yes? No further questions, Judge.
Thank you.
All right, thank you for being here, ma'am. All right, so Mr. Linder, first to you, sir.
Your Honor, I see no history. I'm recommending an ROR to pretrial on both counts. Random testing. I would be asking for a no contact order at this time, Your Honor. I think based on the allegations of what led to the alleged battery, that according to the report, his mother advised law enforcement of what she witnessed, and then his conduct once he was taken into custody, I think a cooling off period would be appropriate.
Okay, thank you, Mr. Romero.
Judge, no objection to the ROR to pretrial. Judge, but I would be wanting to address the no contact order. My understanding, we heard from one of the victims here today under oath, and I believe the other victim is her sister, who is of, I believe, similar viewpoint. Mr. Crosby does want contact with his girlfriend and his family, Judge. You heard from the victim, she is not in fear. She also wants contact. My understanding, Judge, it was not the alleged victims who contacted law enforcement. My understanding is when law enforcement responded and Mr. Crosby was going to be incarcerated or placed under arrest, neither victim wanted to see Mr. Crosby arrested, and I don't believe they want to go or proceed forward on these charges. My understanding, speaking with Mr. Crosby, he's a lifelong resident of South Florida. This is the first time ever being arrested in his whole entire life. So, Judge, I'm asking for our order of pretrial and for the court not to impose a no victim contact order.
Okay, thank you. So with regards to Ms. Mohammed's charge, I will ROR him to pretrial. However, with regards to the other listed victim, without them here, I am setting bond in the amount of $500 plus pretrial release. Once you do post bond, and you need to call in a pretrial release, so please give your phone number to pretrial before I continue with others.
619296480.
What are the first three, please?
561.
561. Okay, thank you. Sir, based on the allegations that this was allegedly a physical altercation based on alcohol and drugs, you were allegedly under the influence of 2 bottles of alcohol in a fight over cocaine. You are going to be randomly screened at least 2 times per week while your case is pending, and you cannot use any drugs or alcohol while your case is pending. Do you understand?
Yes, ma'am.
All right. You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes, ma'am.
And for now, there needs to be a cooling off period. You cannot have any contact, direct or indirect, with either of the listed victims while your case is pending. Do you understand?
No, ma'am, I do not. I do understand your statement, but I believe I should be able to have contact because she just got finished saying that I should. And my sister, she's not here. I'm not sure where she is, but they were both
You're telling me you're not going to stay away. I'm putting you on level 2 with a GPS monitor so we can make sure you're staying away from the listed victims, Mr. Crosby. You're telling the court that you don't understand why you cannot, and you're advising me that you're not going to stay away from her.
Judge, I don't believe he advised that he's going to stay away. He was just confused considering that none of the victims wanted to go forward. So he was requesting the court to reconsider and not impose a no contact order. But if the court does, I went over it with him. He will be abiding by that no contact order. He has no intention of not obeying a court order, Judge.
That's not what I heard, Mr. Romero. So let me try this again. Mr. Crosby, do you understand? I have not heard from the second alleged victim. I've only heard from one today, and I've just advised you there needs to be a cooling off period. So you cannot have any contact, direct or indirect, with either of the listed victims. Do you understand?
Yes,
That means that not only can you not live with either of them, you cannot call, text, email, social media, send letters, have a family member or friend send a message to either of them or any other means of communication that I have not said. Do you understand?
yes,
And you will be abiding by my court order and staying away, correct?
yes, ma'am.
All right. Does your office need to be provisionally appointed?
Yes, Judge.
All right, so I will provisionally appoint the public defender's office to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure they keep representing you. I'll leave it at standard pretrial for now. But Mr. Crosby, please note that there is a stay away order and it has not been altered by a division judge. That is the only way that you could have contact is if your division judge changes this court's order. Good luck to you, sir. Good luck to you, ma'am. Well, he has to postpone first. 5 ROR on the first count regarding Ms. Mohammed and 500 on the second victim. Plus pretrial. Next is Mr. Bahena on page 8.
He's here, present, Judge. Amen.
All right, thank you. Good morning. I do find probable cause for battery, cause bodily harm, domestic violence. Mr. Linder, first to you.
Your Honor, I'm recommending a $2,000 bond, no victim contact. It's based both not only on the level of violence and the injuries that the victim allegedly suffered, but also the paperwork indicates that Mr. Bahena resides in the state of Illinois and lacks ties to the community. I don't see any local history.
Thank you. Mr. Romero.
Judge, that is correct, Judge. Mr. Bahena is from Chicago. Him and the alleged victim did travel down here together for vacation. My understanding, they're from Illinois, specifically, I believe, Chicago area. 30 minutes. 30 minutes from Chicago area, Judge. My understanding in speaking to Mr. Bahena, he has a clean record. He does work as a TV technician, only making approximately $300 a week. So the $2,000 bond is going to be financially difficult for him. Also, one other thing, Judge, he lost his phone. So unfortunately, has no one to contact, I'll post his monetary bond. What we were going to be requesting is the court to consider setting a $500 bond on his behalf and to provisionally appoint my office in an order allowing him to go back to Chicago. He does understand not to have any contact with the alleged victim.
All right, thank you. The alcohol influence box was also checked off, so he's going to have to be randomly screened while he's in Chicago. All right, sir, I am going to set bond because of your lack of ties to the community, as well as the allegations that the victim was punched 4 times in her face allegedly after being pushed onto the bed at $2,000. Once you post your bond, you're going to be supervised by pretrial release, which means you'll have to call in 11 a.m. the next business day after you post bond. You can reside in Illinois while your case is pending, but please note you cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
Yes, Your Honor.
You also cannot have any contact with the listed victim, direct or indirect. Do you understand?
Yes, Your Honor.
That means not only can you not live with her, you cannot call her, text her, email, social media, have a family member or friend send a message to her or any other means of communication that I have not said. Do you understand?
Yes, Your Honor.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. You're going to be randomly screened for drugs and alcohol, like I said, so no drugs and no alcohol. Good luck to you, sir.
Judge, one thing, I don't know if I heard correctly, you provisionally appointed my office?
I did, sir, yes.
I'm going to be requesting a property order, Judge.
Okay, property.
Thank you, Judge.
All right, no problem. Good luck to you, sir. Let me just write that on there. I don't know where. All right, thank you. Next is Mr.
Dennis on page 8.
Judge, if I could just ask, Mr. Romero, that property order, was it to get to the cell phone?
To get his wallet.
Okay, thank you.
All right, Mr. Dennis, good morning, sir. You find probable cause for touch or strike battery, domestic violence. Mr. Linder, first to you.
Judge, I see no local history. I'm recommending a $2,000 bond, no victim contact. It's based on the level of violence alleged and the alleged injury suffered by the victim that caused her to seek medical treatment. Nothing further.
Thank you, Mr. Romero.
Judge, as you heard, Mr. Dennis has been residing in South Florida for over 30 years, more than half, almost half of his life. But more importantly, he has no prior criminal record. He's a registered voter in our community. He's self-employed. He does construction, only making about $250 a week. Considering this is a misdemeanor offense, his lack of priors, Judge, I do not believe that the victim wants to go forward. I'm going to be requesting the court to consider a $1,000 bond on Mr. Dennis' behalf and to sign a phone order so we can try and contact somebody to come up with that monetary bond, Judge.
Based on the level of violence and the alleged injuries that led her to seek medical care for her nose, top of her head, shoulder, back, head and shoulder, not back, sorry, scratch back. I find the state's request to be more than reasonable. I would set a $1,000 bond if you would also be subjected to pretrial release, Mr. Romero.
Judge, respectfully then, since his has prior record and he's going to have to come up or call somebody for a monetary bond, then $2,000 bond on his behalf. We're going to be asking to be provisionally appointed and still a phone order, Judge.
No problem. I'll sign that phone order. I will also provisionally appoint the public defenders to represent you during the pandemic, sir. Once COVID's over, you'll need to reapply to make sure they keep representing you. I will set your bond in the amount of $2,000. The conditions of your bond, even while you're in custody, Mr. Dennis, you cannot have any contact with the listed victim, direct or indirect. You understand?
Yes.
That means that not only can you not live with her, you cannot call her, text her, email, social media, send letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes.
Sorry, a little louder.
Yes, ma'am.
All right, you also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Understood?
Yes, ma'am.
All right, anything else on his case? I've already said I'd sign that phone order.
And a property order. He's going to try and see if maybe he has a credit card in his wallet.
All right, and I'll sign that property order as well. Good luck to you, sir. All right, I'll write it on here. Next is Mr. Felipe Auguste.
He's here, present, Judge.
All right, thank you. Good morning, sir. I do find probable cause for domestic violence injunction, willful violation. Mr. Linder, first to you.
One moment, Your Honor.
And I'll go to, I call him, never mind.
Your Honor, I'm recommending a $2,000 bond, no victim contact. As history, I see a 2019 possession of substituted cathinones, 04 grand theft, 04 burglary, dwelling, resisting with violence, battery on a law enforcement officer. Nothing further.
Thank you, Mr. Romero.
Judge, as you heard, he does have limited contact. I believe the contacts which were mentioned were not recent in nature. He's been residing here almost his whole entire life. He's not working. Judge, and speaking Mr. Philippe, Judge, my understanding is he was served with the injunction on the same day. He thought the person was not home. He was there simply to get clothes. He had every intention of abiding by that injunction. He even went ahead and basically made a reservation at a hotel in order to abide by that no contact order. He has every intention of still abiding by that no contact order. He's asking to be released ROR, and we're asking to be provisionally appointed.
Okay, ROR is not an appropriate request based on the an injunction being served on him that he admitted was served on him. I can put him on pretrial release level 2.
Judge, in that case, what's going to be present a problem, even though he's going to be at a hotel. I don't know how pretrial is going to go ahead and verify that might cause him to stay several nights here in custody. Then we're going to be no objection to the $2,000 bond then, Judge.
All right, I do have an objection to that because I don't believe it's appropriate. He was served with an injunction, advised officers he was served with the injunction, yet was at the listed victim's home. So I am going to put him on a pretrial release level 2 with a GPS monitor because that's the only way I can ensure that he will stay away from the listed victim and her home. Sir, you cannot return to the victim's home. Do you understand?
Yes, Your Honor, I do.
You also cannot have any contact with her, direct or indirect. Do you understand?
Yes, Your Honor.
That means not only can you not go by where she lives, you cannot go by where she works. If she goes to school, you can't go there too. You cannot call her, text her, email, social media, send letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes, Your Honor.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
Yes.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. It was a straight ROR to pretrial release level 2. Good luck to you, sir. Next is Mr. Robinson on page 8.
Is here present, Judge of Maine?
All right, Mr. Robinson, good morning. I do find probable cause for touch or strike battery, domestic violence. Mr. Linder, first to you.
Judge, recommending $1,000 bond, no victim contact based on the level of violence. The only priors Mr. Robinson has are dated drug possession priors. Nothing further.
Okay, thank you, Mr. Romero.
Judge, no objection, asked to be provisionally appointed.
All right, thank you. Mr. Robinson, I'm going to set your bond in the amount of $1,000. The conditions of your bond, sir, even while you're in custody, you cannot have any contact, direct or indirect, with the listed victim. Do you understand? Sorry, was that a yes?
Yes.
All right, that means that not only can you not live with her, you cannot call her, text her, email, social media, have a family member or friend send a message to her or any other means of communication that I have not said. Understand?
He answered in the affirmative, Judge.
Okay, thank you. You also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
Yes.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on Mr. Robinson's case that we need to address?
Nothing else, Judge.
Good luck to you, sir. Next is Mr. Quintana Izquierdo on page 9. All right, sir, good morning. I do find probable cause. Count 1, aggravated assault with a deadly weapon, domestic violence. Count 2, touch or strike battery, domestic violence. Count 3, resisting an officer without violence. Counts 4 and 5. 4 is a signed warrant that you're being held no bond on. 5 is a 94806 violation that you're going to be held no bond on. So with regards to 1, 2, and 3, Mr. Linder, first to you.
Judge, I'm recommending a $10,000 bond on the aggravated assault, a $2,500 bond on the domestic violence battery. Your Honor, just based on the charges that he's on probation for, specifically battery on a law enforcement officer, there is the potential that that charge could get upfiled to a felony battery. Should he postpone and be eligible for release, we're requesting pretrial release of the GPS monitor level 2 based on the alleged threats to kill. Your Honor, we'd also be asking for an order of random testing based on the specific allegations in the report, obviously with an order of no victim contact. Your Honor, Mr. Quintana Izquierdo was also arrested in 2015 for domestic violence battery by strangulation and domestic violence battery against the same alleged victim. Those charges were dropped. My office had contact with the alleged victim this morning. She did voice concerns for mental health issues. We advised her, because of the no bond holds, while the public defender may be asking for a screen, there's nothing really that the court can order as far as treatment this morning, but we will make note of it so our office can advise his assigned judge at a later date, should that become relevant.
Okay, thank you, Mr. Romero.
Judge, I spoke Mr. Quintana. He had a lot to say. My understanding, Judge, is he is denying these allegations. He's looking forward to having his day in court and disputing these. My understanding also is, I believe in speaking Mr. Quintana, I do not believe the victim at the end is going to want to see Mr. Quintana prosecuted or be incarcerated. Having said that, Judge, he's been here his whole entire life. He's self-employed. He does construction for a living. Judge, at this time, considering he has no holds, what we'll be asking the court to consider is a total of a $2,000 bond on the new law offenses. I did advise him he's going to have to go in front of his division judge to seek some sort of relief on his VOPs. He is aware that this court cannot do anything on his VOPs. We're going to be asking to be provisionally appointed on his case, Judge.
All right, thank you. Based on the threats to kill, the court does take threats to kill very seriously. So on count one, I am going to set bond in the amount of $10,000. Based on that, the prior battery Leo conviction, this could be elevated to a felony battery based on prior, sir. So I am going to set bond on count two at $2,500. Once you post bond, you're going to be supervised by pretrial release level 2 with a GPS. If your division judge gives you release on the no bond holds, you cannot have any contact with the listed victim, direct or indirect, even while you're in custody. Do you understand?
Yes, Your Honor.
That means no phone calls, no letters, no having a family member or friend send a message to her or any other means of communications that I have not said. Do you understand?
Yes, Your Honor.
You also cannot possess any firearms, weapons, or ammunition while your case is pending, and that includes knives. Do you understand?
Yes, Your Honor.
Okay, and I also am going to order no drugs or alcohol while your case is pending, and you're going to be randomly screened at least 2 times per week if your division judge gives you release. Do you understand?
Yes, Your Honor.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else in his case, Mr. Romero? Do you want a mental health screen?
No, Judge, not at this time.
Okay, thank you. Good luck to you, sir. All right, next is Mr. Corden. The listed victim is outside, so just give me 1 minute. Can you confirm that that's her name? It's not in the report, Mr. Linder. When we get her name, can you confirm it is her? It's not in the report. Yeah.
Yes, Your Honor, what I can advise the court, and I don't know if it's been put into Odyssey yet, because of the recency, I did speak with Officer Rodriguez this morning, and he provided me with the case number, like that.
Okay, so what's the case number?
DVCE 21-4375-63.
Couldn't find it.
I can also reach out to him, Your Honor, to get the name of the protected party.
Okay, I see it in the petition, and that's the name I have here. All right, ma'am, good morning. You are the listed victim, and your name? All right, ma'am, are you here to see what happens, or did you want to tell me something?
I want you to something about my son.
Okay, so please raise your right hand for me, please. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down, and now that you are sworn, you can state your name for the record again. All right, Ms. Citro, you were here without an attorney, and you previously spoke to law enforcement, so I need to advise you that anything you say today can be used against you at a later date. Do you understand?
Yes.
All right, ma'am, what is it that you wanted to tell me?
I wanted to tell you that my son is mentally ill. I filed watchman. I've been
Judge, we can't hear anything.
She's soft-spoken. Yes, you're soft-spoken. If you could please just speak up. Hear you?
Okay. I am here to say that my son is mentally ill. He's followed by a psychiatrist. He's bipolar, ADD, OCD. He's a danger to himself. I have Watchman Act. The first part was taken from jail to an evaluation, and then I filed a second part for him to go to a long treatment and rehab because he is ill. He just came out from prison on January 30th. That was his birthday. He was good for 2 months. Then he was still okay until the end of May because we had a curfew until 10 p.m. And then in June, when he was free, went down the drain, and he went back to between the prescription drugs, alcohol, and other drugs. He's a total mess. My son needs help. Senior citizen, this is my last chance. I've been doing this for 20 years. It's my only son. He's got to be taken care of. He cannot be released. He needs help. He needs long-term rehab, psychiatry, psychology. He's deeply hurting inside. Something is very wrong with him.
Okay, thank you, ma'am. Mr. Linder or Mr. Romero, do you have any questions for the listed victim?
Not at this time, Judge.
No, Judge.
Okay, thank you. Thank you for being here. You can stay right there and then while we go through the proceedings. Okay. Okay, thank you. Mr. Linder, first you.
Your Honor, and I certainly understand everything that Mr. Kokordan's mother is advising the court. But that being said, because I don't know some of the things she mentioned about him getting certain types of assistance, I don't know that those things can happen immediately upon his release. So there is concern of what his bond and release conditions will be. Your Honor, I'm recommending a $7,500 bond on the violation of injunction. Asking that the bond on the Alprazolam be kept in place. Pretrial release with a GPS monitor, level 2. No victim contact, no return. Your Honor, the case that you were advised of, that he was just released from prison this year, it's a 2017 burglary of a dwelling with a battery, false imprisonment, carjacking, strong arm robbery, burglary of a dwelling, felony battery due to prior convictions, and petty theft. That was against an ex-girlfriend. I reviewed the probable cause affidavit this morning. He originally was sentenced to 5 years probation as a habitual offender. He violated his probation and in December of 2019 was sentenced to 2 years state prison. Hence his release from Florida State Prison late January this year. Nothing further.
Mr. Romero.
Judge, since he's been released, he's been working at a restaurant. My understanding is, speaking Mr. Kokordan, that job and opportunity is still available to him. I believe it's an uncle. Now he's been residing in South Florida for 20 years. He will have to find a separate place where to reside. But unfortunately, when he was arrested, he didn't have his wallet with him. He doesn't have anyone to post his monetary bonds. He doesn't have the funds to post his own monetary bond. He has no one to contact, Judge. He's asking to be released ROR to pretrial.
All right, thank you. That is not an appropriate request based on these allegations and the very serious crimes he just was released from Florida State Prison on. All right, so I am going to set bond on count 2, the injunction at $10,000. I'm leaving the bond in place on count 1, the Alprazolam. Once he posts bond, he's going to be supervised by pretrial release level 2 with a GPS. You are also going to be randomly screened for drugs and alcohol at least 2 times per week. That means that you cannot use any drugs and you cannot use any alcohol while your case is pending. Do you understand?
Yes.
You also cannot return to the listed victims, your mother's home. Do you understand?
Yes.
You cannot have any contact, direct or indirect, with her. And do you understand, sir?
Yes.
That means not only can you not go by where she's living, you cannot call her, you cannot text her. No emails, no letters, no social media, no having a family member or friend send a message to her for you. Understood?
Yes, ma'am.
Or any other means of communication that I have not said. Understood?
Yes.
You cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
Yes, ma'am.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Is there anything else on his case that we need to address?
No, Judge.
All right, good luck to you, sir. Good luck to you, ma'am. Thank you for being here. The random screenings, we hope will help him get clean, okay? Thank you for being here, Ms. Citro. All right, next is Mr. Montina on page 9.
Next to me, Judge.
All right, thank you. Good morning, sir. I do find probable cause for domestic battery by strangulation, dating relationship. It's a filed case. Mr. Linder, first to you.
One moment, Your Honor. Your Honor, I can advise the court that on June 8th of this year, actually late May of this year, the alleged victim sought and obtained an injunction order of protection. It is in place until September 24th of this year. It's a temporary injunction. I'm recommending a $10,000 bond and no victim contact based on the allegation that the alleged victim lost consciousness during this incident. I'm not showing any history, Judge. Nothing further.
Okay, thank you. Mr. Romero?
Judge, my understanding is being Mr. Montina, he's been residing here his whole life. He works at a car wash, only making $70 a day. Now, my understanding, I believe the date of incident on what we're here for was earlier this year. My understanding is the injunction, as the state advised us, was sought and obtained in May. Since then, he's abided by that no contact order. He's had no contact with the alleged victim. He will continue to not have any contact with the alleged victim. My understanding, Judge, he really doesn't have $10,000 to help, or anyone that has that sufficient amount of money to help him post a monetary bond. My understanding, Judge, he has a limited criminal history, but we were going to be asking based on his evidence by him not having any contact order and not having any contact, him being able to abide by that no contact order. We're going to be requesting a $3,500 bond on Mr. Martinez's behalf for him to be provisionally appointed.
All right, thank you. The allegations are that there were allegedly at least 3 separate incidents where he put the victim, choked the victim, one chokehold, and then another alleged 2 hands around his neck, and then another chokehold. And that second chokehold is the one where she allegedly passed out. When she did regain consciousness, it's alleged there was a struggle over a firearm that discharged inside the home. So I do find the state's request to be more than reasonable. I am setting bond in the amount of $10,000. The conditions of your bond, sir, you cannot have any contact, direct or indirect, with the listed victim, even while you are in custody. Do you understand?
Yes.
That means that not only can you not live with her, you cannot call her, text her, email, social media, have a family member or friend send her a message, or any other means of communications that I have not said. Do you understand?
Yes.
And I will also order that you not possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature and the alleged threat to kill. Do you understand?
Yes.
I will personally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case we need to address?
No, Judge.
Nothing else at this time, Judge.
Good luck to you, sir. We have one more domestic violence case, and we're going to take the Spanish interpreter cases. All right, last for the DV cases is Mr. Coleman on page 10. I have to sign them, yes, sorry. All right, Mr. Coleman, good morning. I do find probable cause, count 1, domestic battery by strangulation, dating relationship, count 2, touch or strike battery, dating violence, count 3, carjacking without a firearm or weapon. Mr. Linder, first to you.
Your Honor, I'm recommending a $10,000 bond on count 1, $1,000 bond on count 2, a $15,000 bond on count 3, pretrial release with a GPS monitor level 2, no victim contact. It's based not only on the allegations in this case, but Your Honor, I'm showing that Mr. Coleman has a pending felony from 2018 out of Leon County for armed burglary of a dwelling or structure or conveyance and grand theft of a firearm. He also has from 2016 out of Leon County, resisting without violence, false ID to law enforcement. Nothing further.
Thank you, Mr. Romero.
Judge, and speaking of Mr. Coleman, he's a lifelong resident of Florida. He works in construction. Besides doing that, he's an aspiring musician that doesn't get paid very much. Now, my understanding, Judge, in speaking to him, in reference to count 3, My understanding and speaking to him, it is his vehicle. It may not be registered under his name. However, he's the one that purchased it, and they've been together for quite a number of years. My understanding, Judge, he is looking forward to contesting these allegations. He can live with his mother. His mother is the only person that can post his monetary bond. She works as a telephone receptionist. I'm not going to be able to afford anywhere close to what the state is asking for. Right now, he's also raising 2 kids. His 2 kids are with his mom. The alleged victim is not the mother of his 2 kids, Judge. So he needs to be out there in order to go ahead and help provide for the financial well-being of his children. We were going to be requesting a total of $15,000 bond on Mr. Coleman's behalf with pretrial and to be provisionally appointed.
All right, thank you. I will note that the listed victim allegedly advised officers multiple times that there is a significant history of domestic violence between the 2 parties. Mr. Linder, did the state request pretrial in this case?
Yes, with GPS.
Okay, thank you. Okay, that's what I thought. All right, so I am going to impose bond as requested by the state. Count 1, $10,000, count 2, $1,000, count 3, $15,000. Once he posts bond, if he's able to do so, he's going to be on pretrial release level 2 with a GPS, so he can still work, but so based on the very serious allegations, he's going to be on that pretrial monitor. The conditions of your bond, even while you're in custody, Mr. Coleman, you cannot have any contact, direct or indirect, with the listed victim. Do you understand? Okay, that means that not only can you not live with her, you cannot call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication I have not said. Understood, sir?
Yes, Your Honor.
Speak up.
Yes, ma'am.
Thank you, sir. You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes, Your Honor.
Okay, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case that we need to address?
No, Judge.
I think that Mr. Coleman was advised me because of his work schedule is flexible. We understand the court made a ruling as far as level 2 with the monitor. Would the court consider an open schedule?
Mr. Linder, state.
Your Honor, considering he's already out on a punishable by life offense and now a first degree felony involving violence, in level 2 would be appropriate.
All right, thank you. Based on those reasons, I tend to agree with the state. He has a pending armed burglary that's punishable by life and from another county. So that's more than reasonable. Good luck to you, sir. I cannot revoke that bond in Leon County, but that doesn't mean they cannot revoke it on their own. All right, we do have a Spanish interpreter here, Mr. Rojas. Good morning, sir. Thank you for your patience.